Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice. Nothing in this podcast should be construed as creating an attorney-client relationship. This week, we are talking about trade secrets in our 4 episodes, strategies for protection management, and legal remedies. We have here today with us a special guest, Scott Gibson, an attorney with expertise in the area of trade secrets. Among other things, Scott teaches a law school class on trade secrets as an adjunct professor for ASU Law School, and he wrote a textbook for the class. So he's written the book on trade secrets. We will have a link to Scott's profile with Denter Peterson Dunn, which is more information and links and how to get a hold of him and great resources on trade secrets. So welcome, Scott.
Thank you, Wayne. It's good to be here.
Yeah, so I'm going to start with a story I heard. So there was an inventor who got a patent on his product. He didn't worry about confidentiality because he already had a patent. And so he went to work with a manufacturer, saying, can you produce this? What's your price? Are we going to partner? You share some of the manufacturing costs and some of the profits, that whole song and dance. And he shared specifications, he shared the patent, and they decided they weren't interested in working with him. But then later he found that they had looked at the patent, looked at his specifications, and figured out how to design a product that did the same thing, but avoided his patent, didn't infringe on his patent claims. So is this something you may have heard of or seen before?
I've not seen that particular circumstance, but it is an interesting point. Patents and trade secrets, while they cover many similar things, are 2 different animals, and you need to make sure that you're using the right animal, so to speak, for the protections that you need.
Yeah. So I had a different inventor who I learned about this story because my client was actually working with the same manufacturer and learned about this story later. He did get them to sign a non-disclosure agreement in their negotiations. He had shared with them CAD files. Now, CAD files with very specific specifications aren't going to be in the patent. So that's trade secret, even though it's on patented technology, as long as he can, substantiate, and we're going to talk about that today. What does he need to do to make sure that's a solid agreement? But what we want to focus on real quick is, what are trade secrets? What does it cover?
Good question. It can cover most anything. The definition of a trade secret includes essentially 3 things. First, it's information, and it can be any kind of information that is not commonly known in the industry and has economic value because it's not known. And then probably the most important factor is that it is subject to efforts that are reasonable under the circumstances to keep it secret. So a trade secret can be anything that fits in that definition, but it excludes more information than it includes.
Okay. Yeah, especially with the internet and everything being so publicly available, it excludes all that stuff that's just already published and out there, right?
Not just things that are published and out there. The question, well, let me back up a little bit. A trade secret does not require novelty in the way that a patent does. To get a patent, you have to show that you're the first person who ever did this, developed this product, developed this mechanism, this technology, whatever. For a trade secret, it doesn't have to rise to that level of being completely new or inventive. Rather, it's simply something that is not commonly known in the industry, which means that anything that isn't known in the industry can't be a trade secret. And frankly, that's what most of the information that a business uses is information that is commonly known in the industry in one way or another. So that's why, and we'll talk a little about this later, I think, why it's so important to specifically identify what is and is not a trade secret among what you're using in your information.
Okay. Do you find that there are cases where You think it's better off for someone to keep something as a trade secret rather than patent it?
Yes, probably the primary example you would see of this is the poster child for trade secrets, the formula for Coca-Cola.
Right.
That if you have something that is not likely to be discovered or that is hard to duplicate, you may want to have it as a trade secret. One of the differences between trade secrets and patents is that with a patent, you must tell the world, here's my secret sauce and here's how I do it. In a trade secret, the fact that it is secret sauce and other people don't know how to do it is what makes it special and which entitles it to some sort of protection. So you can have a trade secret like Coca-Cola or KFC's 11 herbs and spices. That is a closely guarded trade secret that's lasted for decades, much longer than patent protection would last. The drawback with a trade secret is that it can be duplicated through reasonable efforts, through proper means. So if I can reverse engineer your product, the fact that you have a trade secret or hold that as a trade secret does not prevent me from reverse engineering your product and duplicating it.
Okay, yeah. And there are some pretty advanced reverse engineering techniques. I know in the semiconductor industry, they routinely have, when they do this to see infringement of patents, they have a machine that cuts off one really thin layer at a time on a microchip so that they can then take a picture and just do it over and over, and they can recreate. Circuits are really like buildings. They do them one layer at a time. And so if you're cutting off one layer at a time, you can actually see all the circuitry inside that microchip. So that's a simple example of reverse engineering.
And that would be a case where you might want to patent.
Right.
Because you don't, with a microchip, you don't need a long time protection because the technology will be obsolete in the next, year and a half?
Yeah.
Or less. So you want to get the patent protection to keep people from coming into the game while you're there.
Yeah.
During the term of your protection.
Yeah. Do you think that it's a majority or a minority of companies, small businesses, that need some level of trade secret program? Is this something just reserved for the cutting edge technology companies?
It's not. Every business has certain aspects of it that likely qualify as a trade secret. Certainly you have confidential information that should not be shared with others, even if it doesn't rise quite to the level of a trade secret protection. And so I think it's critical that companies look and evaluate what their secret sauce is and determine how do we best protect that. There's no one size fits all. It's going to depend on what your technology with the small t might be and how you can best protect that. Maybe you protect it with a trade secret. Maybe you protect it with a patent. Maybe you just keep things under lock and key so that it's not readily accessible for everyone to see.
Yeah. What are the advantages of trade secrets over patent protection?
The advantages, some of the advantages are actually some of the disadvantages as well. There's no organization that where you register your trade secret.
Right.
There is no one, you will not get a certificate that says you have a trade secret for the formula for Coca-Cola. That means the trade secret is not formally defined by a governmental agency anywhere. Now we're going to come back to a theme that I'm going to hit on again and again. That's why you need to figure out what your trade secrets are and identify and document and secure them early on so that you can show that your thing, your secret sauce really is a thing. I like to explain it as your innovation, your trade secret is kind of like air. You can't see it, smell it, touch it, feel it, but it's there. And part of what you have to do in developing your trade secret and your trade secret program is to make that thing become real, to give form and substance to your intangible asset, which is an idea. And then do that in a way so that the court, if you ever have to go into court, the court can say, yeah, it is a real thing and you took reasonable steps to protect that.
What is it that our listeners can do to assess? Is there something they could do today to assess, should I work on a trade secret program in my company?
I guess you need to look and say, how is your company different from the competitors? And it needs to be different in the way that really is different. I kind of like to explain it as our businesses, we feel like it's our children, the business is our child. And of course our child is special and noble and wonderful and the most talented child ever. And the truth is, most of what's there is probably pretty ordinary, which is not to say that it's not valuable or important or good. It's just to say it's not all that different from everything else. So part of what you have to do as a business owner is to figure out, what do we do that is truly outside the box of what others in our industry do?
Okay.
And then,
well, we're out of time for this segment. We're going to come back in just a couple minutes, and we're going to keep talking about trade secrets and the first step in protecting a trade secret. You've been listening to Leveraging Inspiration, the Inspired Patent Podcast. We are live on ibgr.network at 3 p.m. Eastern Time every Friday. You can also find us anywhere you find your favorite podcasts. Our show today is sponsored by Inspired Idea Solutions Law Firm, an IP boutique law firm where we put your strategy first, use a proven process for success, and guarantee zero hidden fees. You can find us on the web at z3ip.com. That is Z as in zebra, the number 3, and IP as in intellectual property.com.